Adi, thank you for being here. I'm very glad to see many of my students and other faces that I know very well. And we have a very good audience, so we're very glad for that. Today, we will discuss the right to a safe and healthy environment in international law under an holistic perspective. We have very important guests from different countries that you will have the opportunity to listen and that will offer very different perspectives on the topic that will be the object of discussion. And we also have the honor to have with us our rector, Professor Roberto Di Pietra, and I immediately give the floor to him.
Thank you to Professor Lenzerini, thank you Federico, and thank you to all the invited and keynote speakers of this afternoon here at the University of Siena. This is really a relevant topic, despite what some people want to say in these strange years. I mean, there are some people questioning the importance and the relevance of this topic. But this is a topic that is definitely relevant. I don't know if when you scheduled this event this afternoon, you were aware about the fact that these were the days of the COP30 in Brazil, but it is. So there is a coincidence, and this is maybe important. I know that this conference today is, I mean, a part of the research program funded by the Ministry of University and Research. That is a program, a research program. I mean, the first title, the main title is Intergenerational Solidarity. And this is a part of the issue. To me, and in my opinion, it is not only a problem of solidarity, it is a problem of our duty, my generation, to this generation and the forthcoming generation. So it is a matter of duty. We must find a way to ensure a right that is the safeness and the healthy environment, and the environment that is safe. So we must do something, and we must revert this trend. This is what we have to do because we are the cause of this situation. There are some people stating that, and there are some countries supporting the idea that they have the right to pollute because the Western countries have already polluted. So they want to say, you have already polluted, so this is our time to pollute. I mean, this is an argument in different tables where we are discussing about climate change, in which some countries, some, I mean, regions of the world wants to support this idea. And this is, in my view, not an intergenerational solidarity and not a worldwide perspective, because we are in a unique earth, in a unique planet. So it doesn't any sense. But we need to support this idea. We need to support the idea that it is not a problem to give or to allow other economies to pollute because they haven't yet already polluted as the Western countries. It is important to remove from the table this argument, because otherwise we are not able to revert the situation in this planet. Let me say something about the University of Siena. We are supporting this idea about the climate change and about the actions we need to, I mean, put on the table in order to change and to create awareness in our students and also in their different professionalities. Because this is what we do here in this building when we discuss about law and political science, but this is what we do in other buildings, in other areas, disciplinary areas of the University of Siena, when we approach these topics from the economic point of view, the finance point of view, the management point of view, the biology point of view, the life sciences in general point of view, and in many other disciplines. We are supporting this idea, and we would like to foster this kind of awareness in our students and in their, tools of competence, whatever is the topic they are attending in, the graduation level or in the Master of Science level, because this is exactly what we have to do as a university in Italy and as a university within the European Union. So thank you for the opportunity to exchange ideas about the safe and healthy environment from the law perspective, because this is, tremendously important. Thank you again, and have a nice afternoon. Thank you.
Good afternoon, everybody. My task in this first part of the afternoon is to chair and lead the floor for the discussion. I'm feeling a little bit daunted by the parterre of the speakers, so I'll try to do my best anyway. And I will remind the speakers, if they do not mind too much, when they reach the 25 minutes of their speech, just to give them an idea of how the time is running. Okay, so the first speaker this afternoon is Professor Riccardo Pisillo Mazzeschi, who is Professor Emeritus here at the University of Siena, our Department of International and Political Sciences, Professor Emeritus in International Law. Professor Pisillo Mazzeschi is presenting a paper. The title is International Law, Solidarity and the Right to a Safe and Healthy Environment. Professor Pisillo, the floor is yours.
Okay, thank you for this invitation to Professor Lenzerini and the other organizer of this event. Now I start. The right to a safe and healthy environment has been established by means of a long normative process. This development initially took place through several declarations, reports, and acts of soft law, particularly within the UN institutional framework. Notable examples include the Stockholm Declaration on the Human Environment, the Rio Declaration on Environment and Development, the Centini Report, and the Johannesburg Declaration on Sustainable Development. Additionally, this human right has been incorporated into some important regional human rights treaties concluded after the 1980s, such as the African Charter on Human and People's Rights, the Protocol of San Salvador, and the Arab Charter on Human Rights. In more recent years, the process towards recognizing a self-standing right to a healthy environment has accelerated. In this regard, key developments include reports by special rapporteurs on human rights, obligations relating to the enjoyment of a safe, clean, healthy, and sustainable environment, and subsequently on the human right to a clean, healthy, and sustainable environment. A series of resolutions by the United Nations Human Rights Council on human rights, the environment, and climate change. The landmark adoption by the General Assembly of the United Nations of Resolution 76-300 in 2022, which formally recognized I quote, the right to a clean, healthy, and sustainable environment as a human right. And ultimately, the General Comment number 27 of the Committee on Economic, Social, and Cultural Rights. Moreover, the recent advisory opinions rendered by the International Court of Justice and by the Inter-American Court of Human Rights concerning the obligation of states in respect of climate change also affirm the existence of this human right. Given this, we must ask whether the right to a healthy environment can be defined as a right of solidarity. The answer is affirmative if we mean that this right belongs to the so-called third generation of rights, sometimes defined as solidarity rights. The same holds true if we mean that the right to a healthy environment constitutes not only an individual right, but also a collective one. In this respect, one may recall, among others, the two advisory opinions of the Inter-American Court of Human Rights, number 2317 and 3225. However, the issue becomes more complex if we ask whether the right to a healthy environment is governed by a genuine international legal principle of solidarity. In fact, there is no agreement among scholars as to whether such a principle exists, and if so, what its content and scope of applications are. As early as the first decades of the 20th century, some authors upheld the existence of the concept of solidarity in international law. Yet, in their view, this solidarity was a factual and social or moral notion that still needed to be translated into legal norms. In more recent times, part of contemporary scholarship rejects the idea that solidarity constitutes a principle of international law and argues instead that it represents only an aspiration for the future or merely a moral means of legitimizing international law. Conversely, another, perhaps majority strand of scholarship affirms the existence of a legal principle of solidarity, which has emerged or is in the process of emerging in contemporary international law. These scholars draw their conclusions from the examinations of various areas of international law from which such a principle might be inferred. These typically include the UN collective security system, international human rights law, international environmental law, international development law, international trade law, and the law of state responsibility. Sometimes other branches of international law are also included. The United Nations independent expert on human rights and international solidarity also supports the principle of solidarity. She prepared a draft declaration in which solidarity is conceived not only as a human right belonging to individuals and peoples, but also as a foundational principle of contemporary international law. However, even among those who support the principle of solidarity, there is no agreement on several key points. Is it a true binding principle of international law? What is its precise content? Does it govern the entire international legal order or only certain areas? And if so, which ones? The key point for my purposes is that most authors end up identifying the concept of solidarity with that of cooperation, or at least conceive of solidarity as an intensive form of cooperation. In my view, this identification between the two concepts tends to overextend the scope of the principle of solidarity and dilute its effectiveness. Indeed, the concept of cooperation is broad and generic, especially when the objectives, forms, means, and enforcement mechanisms of states' cooperative commitments are not clearly specified for each area of international law. In essence, in my opinion, solidarity, if it is to have a legal and binding character, must constitute a more precise and restrictive concept, capable of establishing among states a stronger and more effective bond than the vague notion of cooperation. In this respect, the thesis of Professor Wolfram is interesting. It limits the main meaning of the solidarity principle to the pursuit of common goals through joint state action within normative regimes designed to protect common goods shared by those states. However, beyond this requirement, with which I agree, I believe that the principle of solidarity should be even more restrictive, also focusing on issues of responsibility and systems of collective guarantees. In conclusion, the principle of solidarity should meet 3 criteria. A, joint and effective action to protect common goals and values. And B, the widespread presence of erga omnes obligations aimed at safeguarding those values and the possibility of reacting to their violation. And C, judicial or quasi-judicial collective guarantee mechanism among states bound by solidarity. These 3 criteria seem necessary to mark the qualitative shift from a mere principle of cooperation to one of solidarity. My thesis is that solidarity, understood in this restrictive sense, is incorporated into a true general principle of international law, but that such a principle is not universal in character and operates only in certain limited sectors of international law. I also believe that this principle displays different characteristics and effects depending on the field in which it applies. Having established this, one must now ask whether the right to a healthy environment and more broadly the field of human rights protection is governed by the principle of solidarity. Many scholars identify international human rights protection as a key normative sector for the principle of solidarity. More specifically, following the influence of 2 well-known writings by Vasak, these scholars argue that the principle of solidarity is embodied in the so-called 3rd generation of human rights, particularly the rights to a healthy environment and to development. Now, the arguments supporting this thesis are essentially threefold. First, these rights would impose joint obligation on all states since their realization requires collective and global action. Second, they would impose obligation not only on states, but also on other actors in international society. And third, they would be collective rights belonging to peoples and groups of individuals. These 3 characteristics would distinguish these rights from those of the 1st and 2nd generations. Specifically, with regard to the right to a healthy environment, it is argued that the principles of sustainable development, intergenerational equity, and common but differentiated responsibilities reflect the broader principle of solidarity. In my view, these arguments are not entirely convincing. First, I believe that all human rights impose joint obligations, also known as erga omnes or erga omnes partes obligation. Second, all human rights impose obligations on states, but sometimes also on individuals and groups. And third, these so-called third-generation rights are both collective and individual. Therefore, I cannot agree with those who would apply the principle of solidarity only to these specific human rights of so-called third generation. Given this, we must ask whether the entire field of international human rights protection is subject to the principle of solidarity. Based on the restrictive definition proposed above, the principle should entail joint action for the protection of common goods or values, the widespread presence of state obligations erga omnes, and the existence of institutional, judicial, or quasi-judicial collective guarantee mechanism. Now, the first requirement can be considered fulfilled for all human rights, at least within the universal United Nations system of protection and the regional systems in Europe, the Americas, and Africa. The second requirement, erga omnes obligations, also appears to be met for all human rights. As for the third requirement, guarantee mechanism, a positive answer may be given for the aforementioned regional system and with some optimism also for the United Nations universal system. Ultimately, we can cautiously affirm the existence of a general principle of solidarity across the entire field of international human rights protection, and consequently, the right to a healthy environment is also subject to the principle of solidarity. What are the effects of this principle? The question is complex and would require an in-depth inquiry into the foundation and nature of general principles of international law, which cannot be undertaken here. In short, my view is that contemporary international law contains a mixed regime of general principles encompassing different categories of principles with distinct foundations and natures. Specifically, one should distinguish three major categories. First, principles derived by abstraction or by induction from existing customary norms. Second, principles recognized and accepted by the international community as binding. And third, principle recognized and accepted by the international community as programmatic. It seems to me that the principle of solidarity in the field of international human rights protection has mostly a programmatic character. And so its effects are, first, serving as an interpretative aid for existing customary and treaty norms. Second, providing systematic coherence to such norms. And third, driving the progressive development of the field of human rights. And finally, with regard to the right to a healthy environment, I believe that the principle of solidarity has played a key role in its progressive development and consolidation. Thank you.
Thank you, Professor Pisillo-Mazzeschi, also for being very, very well on time. I would like now to leave the floor to, and I apologize because I'm going to mispronounce your name, so just saying it and then butts, to Professor Nico Schrever, Professor Emeritus of Public International Law at Leiden University in the Netherlands. The presentation by Professor Schrever is titled "The Right to a Safe and Healthy Environment as People's Rights." Professor Schrever, the floor is yours.
Thank you very much, Madam Director, Mr. Rector, dear colleagues, dear students, also colleagues, because we always remain students throughout our life. It's a great pleasure to return to the beautiful city of Siena and to be in your audience with so many young people who are all, of course, entitled to the full realization of a human right to a clean, safe, healthy and sustainable environment. That is, of course, what we wish for all of you. But at the same time, we have to work very hard on it jointly, because as the previous Professor Pisello Mascecci stated so well, it is programmatory law. It is not really established human right that you can go tomorrow to a court and claim these rights. We have to work on it. And I do agree that a major key development was the adoption in July 2022, only 3 years ago, of a resolution by the UN General Assembly, which provides powerful evidence of the existence of these rights. But basically, that was the first time, because as Professor Pisello Mascecci stated, we had the Stockholm Declaration in 1972, we had the Rio Declaration 20 years later, and other documents, but they always hinted at it, but they never called it so clearly in a resolution, a human right to environment, as the General Assembly did in 2022. And moreover, this was a Costa Rican initiative and very carefully negotiated within the international community. I think it is important to note that 161 states voted in favor, none against, with 8 abstentions, including Russia and China and a few others. So there was an overwhelming majority. But it may also have been at the cost of some clarity. If you study the resolution, as usual, it has a preamble, an opening part, and an operative part. And the preamble is very beautiful, quoting all these documents and noting that it is people-centered and it is also for the future generations, etc. But then basically the resolution itself consists of only a few lines. That it recognizes the right to a clean, healthy and sustainable environment, notes that that it is very much related to other rights, but also to existing international law, that it requires the full implementation of multilateral environmental agreements under the principles of international environmental law. In a way, it is a bit disappointing because then they fully position it within the field of international environmental law and not so much to all the other areas mentioned by the professor a moment ago. We also would like to see it in international economic law, in human rights law, in world trade law. But unfortunately, in paragraph 4, indeed, they say it is not only for human beings. We also do not call only upon states, but also on business enterprises and all other relevant stakeholders. It was indeed important that the International Court of Justice, based in The Hague in July of this year, just a couple of months ago, also referred in its climate advisory opinion, very important document, I think we will refer many times to it this afternoon, to this new clean, healthy and sustainable environment human rights. And also the court basically endorses the view that that is a precondition for the enjoyment of many human rights, including the right to life, including the right to health, including the right to an adequate standard of living, for access to water, and the right to food, and the right to adequate housing. So it is important that the principal judicial organ of the United Nations, sometimes also called the World Court, tells, well, this is not just a human right. It is inherent in the enjoyment of other human rights. It is almost a precondition. It is an essential, in the words of the court, for the enjoyment of other human rights. I noted that in the title of this fascinating conference, indeed the term solidarity right features. And Professor Piselo Mascecchi said already very interesting things about it, that we have indeed that concept of solidarity human rights, sometimes also called the third generation. And the first generation is civil and political rights, the second one, economic, social and cultural rights, and the third generation are the so-called solidarity human rights. I must admit that I never liked the term generation, because it is, first, is that something of the past, of soon to be of the past, civil and political rights? Of course not. The right to life, very important. And the right to food, second generation. So I like the term categories. You can indeed classify them. And Karel Vazak, indeed, was one of the first from the Strasbourg Institute for Human Rights already in the 70s to use the term solidarity human rights. And then we are talking about, very interesting human rights, including the rights to development and the rights to peace, to mention another somewhat controversial human rights. But also, in my view, the rights to humanitarian assistance. Also in these days of warfare in Ukraine, in the Gaza, I think the right to humanitarian assistance as a solidarity right is an essential human right. And arguably, the right, the established right, the very widely recognized right of self-determination, also belongs to this third category, as a group right, as a people's right. But indeed, this resolution is new in the sense that really for the first time the rights to environment, conducive to development, is called a human right. And in a way that connotates directly with individual human rights. I'm a bit disappointed that in the resolution itself, there is no reference to peoples. Well, they recall to people-centered development, and they refer several times to indigenous peoples. They refer to future generations. But the connotation, and probably in order to get these more than 160 states on board, they position it more as an individual human right. Yet, if you want to implement it, and if you try to analyze the right to a healthy environment, then of course collective action is required. And it affects not only just an individual, but also the community, the nation, the people, humanity as such. So it also bridges, in a way, the gap between individual and human rights. So that indeed brings it into that third category of human rights, that it is bridging rights. It bridges the generations or the categories. It bridges civil and political rights, including the right to life, with economic and social rights, the right to food, the right to health. So it is a bridging right. It is also an integrative right. The International Court of Justice labeled it as essential for the enjoyment of many other human rights. And in a way, if you see these adjectives, clean, healthy and sustainable, it brings together many human rights. It is also a cluster right. So my particular contribution today focuses on the question, to what extent is it also a right of peoples next to a human right of individuals? And of course, we have also the word environment in it. And neither for peoples nor for environments, we have established legal definitions. Of course, when we talk about the environment, we know what it means. The ecosystems, the climate system, biological diversity, but also the wind, the currents, the waves on the oceans, the temperature. So I always don't try to define exactly in legal terms what is the environment, but I like very much what the International Court of Justice stated about this in a previous advisory opinion on the use, the threats or the use of nuclear weapons. Don't get afraid. There was an advisory opinion about that in 1996, and the court stated, I quote, "The environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn." So that is quite a beautiful description of what environment means, and that is what we are talking about. And as regards peoples, strange enough, we know what is a state. You need people, you need a territory, you need a government responsible for the international relations on behalf of the state and the people. But we don't know exactly what is a people. Notwithstanding the absence of a legal definition, like in the case of the environment, we know what peoples mean. A same race, that you belong to a certain ethnicity, that these are objective criteria, that you speak more or less the same language, that you have perhaps a common religion or other joint cultural practices. And perhaps these are relatively objective criteria, but you can also put it into the domain of subjective criteria. Do you really feel that you belong to each other as a people? Do you feel Italian or Toscanan? Do you feel that you are part of the same group? Do you feel a solidarity? Are you willing to stand up for your rights as a people? Well, the people, the concept of peoples is a very widely accepted notion already in the United Nations Charter, mostly a document for states now. But the famous opening phrase is, "We the peoples." We don't want to have any longer these world wars. People should not suffer from armed clashes. And peoples should be entitled to self-determination. And there are many references in Article 1, in Article 2, in Article 55 of the Charter, that we need a new international legal order based upon the principle of equal rights and self-determination of peoples. And we want to have higher standards of living for the people and conditions of economic and social progress and development. And no doubt, the Charter is a living instrument, you could add environment to it. And so peoples have rights, most notably the right of self-determination, which was elevated just from principle in 1945 into a right of peoples to self-determination. For example, in the Decolonization Declaration of 1960, and elaborated in a very interesting way in the Declaration on Principles of International Law, adopted when the United Nations existed 25 years in 1970. And that lists 7 principles of the principles, the most important principles of United Nations law. And number 5 is self-determination of peoples, including the economic dimension of it, economic self-determination, for example, for your own livelihood, for the management of natural resources. And from that also the right to development as both a human right and a people's rights emanated. So that is also a collective human right and part of that solidarity group, that part of the structural approach to human rights. So we view peoples as legal subjects of international law, most notably in the field of self-determination rights in all its variations. Peoples as opposed to states. And we have the subcategory, widely recognized, we will discuss that a lot this afternoon, of indigenous peoples. But we have increasingly also the collectivity of peoples, the past generation, the present generation, and future generations, peoples yet to be born. So I worked on a kind of category of a kind of catalogue of people's rights, and I came to the number of 8. And the first one is, of course, the people's right to exist. So the Anti-Genocide Convention. Nobody is allowed to kill a people. The right to exist and to continue to exist as a people's right emanates from that Genocide Convention and from human rights law, the right to life in general. Secondly, the right to political self-determination of peoples. A key legal principle nowadays widely recognized. And the third one is the corollary of it, the right to natural wealth and resources and the own means of subsistence. And number 4, the right to development. A substantive right, the right to have a decent living, an adequate standard of living, but also the right to active, free and meaningful participation in life. And number 5 is indeed the right to a healthy environment conducive to development. And number 6 is the right to cultural identity, very important people's rights. Number 7 is the right to sustainable development with its economic, its social, its developmental connotation. And then number 8, I mentioned it already, the right to humanitarian assistance. And indeed, we can find, as far as the incorporation in international law is concerned, quite a variety. Of course, the right to self-determination is much more recognized and embedded in international law, not only in treaty law, like the United Nations Charter and the African Charter of Human Rights, but also it is a norm of customary international law. And you cannot yet say that for the right to a healthy environment, in my view. So you have always to see what is the level of incorporation in international law and look to treaty texts, look to customary international law, study very well United Nations declarations, because very often they are the forerunners of the formation of customary international law, or the forerunners of treaty law, as we have seen with self-determination, etc. And nowadays we see this also in Security Council resolutions, also elements of the emerging rights to an environment. The resolutions of the Security Council, for example, with respect to Palestine, with respect to the Great Lakes region, or the Horn of Africa, including the Sudan, they also formulate there is a people's right to exist. There is a people's right to self-determination. There is a people's right to the natural resources, and you cannot destruct the habitat. You cannot destruct the environment of peoples. So these are very important examples of the incorporation of the emerging rights to environment bit by bit into sources of international law. You can also see it in the jurisprudence. It is now not up to me. The time is not really on my side. I still have some time, but I'm sure my colleagues will refer to the very interesting front-running jurisprudence of especially the African Court of Human Rights, the Inter-American Court of Human Rights, which is ahead of Europe in recognizing these solidarity human rights. And that is very interesting. But also in the jurisprudence of the International Court of Justice, for example, that recent advisory opinion, you can find very interesting quotations which indicate that also The Hague, the principal judicial organ of the United Nations, recognizes that, for example, intergenerational equity is an overall guide for the interpretation of the applicable rules of international law, and that due regards for the interests of future generations and the long-term implication of conduct, for example, in the field of climate issues, the emissions now, and the failure to combat climate change, that from the point of view of equity considerations, needs to be taken into account where states contemplate, decide, and implement policies and measures, and see whether that fulfills their obligations under the relevant treaties and customary international law relating to future generations of human rights. That is paragraph 157, also a very important element, but you can also find it in the jurisprudence concerning particular cases between the Democratic Republic of Congo and Uganda, or in the Palestine advisory opinion, and other examples. So let me come bit by bit to a conclusion in a few minutes. I feel it is a very, very important right, and it is recognized in various sectors of the United Nations system. Let me also mention, next to the courts and the tribunals, the very important work of the Human Rights Committee of the United Nations. I myself served for 8 years on a sister treaty body in the field of economic, social, and cultural rights. But the Political and Civil Rights Committee in recent years, from 2022 on, also referred to the rights of peoples to exist and the right of peoples to enjoy the territories and the natural resources and their culture. For example, in a famous case of the Straits Islanders in the Torres Strait, East Timor Islands, in the case against Australia, and a similar case against New Zealand. And there you see the right for their subsistence, the right for their cultural identity, as an element of the right of self-determination fully recognized. So peoples do have a firm and widely recognized status as legal subjects of international law, in the sense that they have rights, but duties as well, also towards future generations. And in selected fields of international law, they have a qualified international legal standing before international organizations and sometimes even international courts and tribunals. And I believe the right to environment is, as my colleague professor from Vienna stated, a programmatic human right. It is emerging and it has to be consolidated. And of course, the advisory climate opinion of the court was extremely helpful to consolidate and even to strengthen the status of this particular resolution of only 3 years ago by quoting it and by endorsing it. But it has to be get more flesh and blood, and therefore this conference, I think, is extremely important. And we should see it indeed as a bridging right, bridging civil rights, the right to life, but also economic, social, and cultural rights, including cultural identity, the habitat, how important for people. We should see it as crossing the 3 categories of human rights. And then we, no doubt, will see that it becomes more part and parcel of the integrated approach of human rights law, which hopefully also embeds itself in international economic law, not only international environmental law, but it's very important in international development law, international economic law, in state responsibility law, etc. And part of what we could call, but not necessarily have to call, solidarity rights are of course extremely important for the ultimate aim to realize a clean environment, pollution-free environment, to realize the right of all people to a healthy life, not only an individual right, but also a group right and people's rights, and to the best of all worlds, a sustainable environment conducive to development with its economic and social and environmental dimensions. But to realize that, I do believe indeed that also the principle of solidarity in general international law has to get a much more firm status than it currently has. Thank you very much.
Thank you. Thank you, Professor Scriver. And now I would like to leave the floor to our host, Professor Federico Lenzerini, who is Professor of International Law here at the Department of International and Political Sciences. The title of his presentation today is The Right to a Safe and Healthy Environment and the Practice of the European and Inter-American Courts of Human Rights. And I would also like to have this occasion to thank him for asking me to join the conference today. Federico, the floor is yours.
Thank you very much. Thank you, Professor Viviani. Professor Viviani is not only the director of the Department of Political and International Sciences, but she's especially a friend and a colleague that I estimate a lot. So thank you for having accepted my request to chair this session. So I would like also to thank my students and all the students who are present here, the colleagues, everybody. I really appreciate your participation, and I hope that this occasion will be good for you to enrich your knowledge in this field. But as I always tell you in class, when we meet with the students, is always a mutual enrichment, no? So we try to give something, but we receive a lot. And this applies to our work all the time. So my topic is the practice of regional courts, in particular the European Court of Human Rights and the Inter-American Court of Human Rights in the field of the recognition of the right to a safe and healthy environment. Then we will have a specific presentation on the African Court of Human and People's Rights by our guest judge, Rafa Benachur. And my students know very well that I really prefer the approach of the Inter-American Court and the African Court in comparison to the European Court, for their capacity to be much more revolutionary in the recognition of new rights and their courage in bringing these new rights in the international fora. So I will devote less time to the European Court of Human Rights and more time to the Inter-American Court of Human Rights. But as regards the European Court of Human Rights, the evolution of the idea of the existence of a right to a safe and healthy environment has occurred mainly in the context of the so-called greening of human rights or greenwashing of human rights. As my students know, we have discussed this issue in class, in the sense that the right to a safe and healthy environment is recognized indirectly as an essential prerequisite. This was also emphasized by Professor Schreiber in his presentation, an essential prerequisite for the actual enjoyment of other human rights. They are explicitly recognized by the relevant treaty, in our case, the European Convention on Human Rights. And this kind of approach has lasted for decades, starting from the very well-known cases of Lopez Ostra versus Spain, or the judgment goes back to 1994, or the case of Guerra and others versus Italy, judgment of 1998. These were cases concerning polluting emissions by factories, which affected directly the applicants. So the applicants suffer interferences, especially with their private and family life. Just imagine that you open the window of your house and you are invaded by smelling and polluting emissions of gases of kind which is not good to human health. So the European Court of Human Rights has always recognized the existence of this right in the presence of a direct effect for the applicants themselves. The recent case, which is very well known, concerning Switzerland, Verein, Klima Signorina, Schweiz, and others versus Switzerland. Professor Wolfram will forgive me for my bad pronunciation of German. Sorry. Appeared to inaugurate a new approach by the European Court of Human Rights, because that was a case brought in front of the court by an association of women, and it was brought by both the association in itself and by some of its members. They were claiming that the lack of adequate action by the Swiss government against climate change had caused direct harm to them, especially because climate change is the effect of heat waves, and due to these heat waves, the applicants have suffered limitations in their family and social life, limitations of various kinds. despite the fact that the title of the case refers to young ladies, but their average age was about 80. And so they were unable to, for instance, go out in the central hours of the day. They were unable to go to the supermarket at times when they were used to do before. So they had to go out only in very early hours. Some of them had to find a place of their house to go to another area which was less affected by heat and so on. And in this case, the European Court of Human Rights recognized responsibility of the Swiss government for not having taken sufficient measures in order to prevent the effects of climate change, especially the Swiss government had not complied with its main climate change goals, had not quantified rates of carbon emissions, and in general, there were several shortcomings in the behavior of the Swiss government concerning the management of the effects of climate change. So in the end, the European Court of Human Rights recognized, on the basis of scientific evidence, according to which heat waves would be the direct consequence of climate change, recognized the responsibility of the Swiss government that was considered responsible for the violation of Article 8 of the European Convention on Human Rights concerning the right to private and family life, and also with regard to the association only and not to its members, violation of Article 6 concerning the right to a fair trial, because there had not been adequate access to justice by the association against the effects of climate change. And apparently, this judgment can be considered as changing the approach of the court. I mean, it is remarkable if we consider that, first of all, it is virtually impossible to determine the exact degree of responsibility of the behavior, the bad behavior by a government over certain effects suffered by individual persons. And also we should consider that, I mean, the claim was against Switzerland, but Switzerland is a little country. And even if we would have envisaged a very virtuous behavior by Switzerland, Switzerland alone would be unable to prevent the effects of climate change if the other states would not contribute to a similar extent. But this notwithstanding, the finding of the European Court of Human Rights was still based on the existence of a direct effect of the action of the government with regard to the applicants. And this has been confirmed quite recently in two decisions on admissibility by the European Court of Human Rights, the first one by the Grand Chamber. And in both cases, the court found the application inadmissible for the reasons that I'm just going to tell you. The first case is Duarte, Agostinho, and others against Portugal and 32 other states. So the applicants probably, I would say correctly, for the reason that I was explaining earlier. No, the responsibility for climate change is to be attributed to all countries, not just to one. So even though they were living in Portugal, they brought before the court other 32 countries who are parties to which are parties to the European Convention on Human Rights, because according to them, these countries share responsibility for the effects of climate change. But the court said that with respect to these 32 countries, the requirement of jurisdiction was not satisfied because there was no effective control by those countries over the destiny of the applicants. And this is quite fun, in my opinion, because we are talking about not of a case of torture or deprivation of liberty or another violation of human rights that are established by the Convention. We are talking about the sui generis rights in the context of which the protection must be ensured through cooperation or through a genuine commitment by all states. So applying the principle of which governs admissibility of state jurisdiction, like for the other rights of the Convention, does not appear really proper. So in this case, the court recognized that there was jurisdiction only for the state of Portugal, but considered the case inadmissible due to the fact that the applicants had not exhausted domestic remedies. So the applications was considered inadmissible and there was no room for considering it with regard to the merits. And even more recently, on the 30th of May of this year, there was another decision of the European Court of Human Rights, the case of Elena De Conto against Italy and 32 others. So even in this case, the applicant had followed the same approach of Duarte Agostinho and others, bringing several states in front of the court. And even in this case, the court denied the existence of jurisdiction for the other 32 countries, so the case could only be related to Italy because the applicants lived in the Italian territory. And they were claiming that there were certain effects of climate change, especially storms, that in the past were not so frequent and that they have become more frequent in recent times, had produced effect to their detriment. But in this case, the court, in the words of the judges, reiterated the approach adopted in the Swiss case and said that there are two main criteria in order to recognize the violation of a right to a safe and healthy environment with respect to individual persons. The first criterion is that there must be a high intensity of exposure of the applicant to the adverse effects of climate change. And then there must be a pressing need to ensure the applicant's individual protection. And the court reiterated that the threshold for fulfilling this criteria is especially high. So basically, the court considered also this application inadmissible using the reason that there was no sufficient direct effect supposedly determined by climate change with regard to the applicants. So basically, in the jurisprudence of the European Court of Human Rights, there is an exclusion of all cases that do not directly, imminently, and severely affect the enjoyment of rights, and there is the need to ensure the applicant's individual protection with high intensity of exposure of the applicant herself or himself to the adverse effects of climate change. So the practice of the European Court of Human Rights is still very, I would say, traditional. Sorry. Going to the Inter-American Court of Human Rights. In the first part of its practice, so in the less recent part of its practice concerning the existence of a right to a safe and healthy environment, the Inter-American Court of Human Rights followed the same approach of the European Court of Human Rights. So the right to a safe and healthy environment could be protected indirectly because it was considered an essential prerequisite for the effective enjoyment of other rights protected by the American Convention. And this was declared by the court, especially with regard to indigenous peoples and their special connection with their traditional lands. One of the main cases in this respect is the case of the Kalinia and Lokono peoples versus Suriname, judgment of 2015. But then, with the advisory opinion 23 of November 15 of 2017, the court partially changed its approach. First of all, in this advisory opinion, the court declared the existence of a right to a healthy environment of an autonomous nature, which means that it is independent for any other rights provided for by the American Convention. And this autonomous right to a safe and healthy environment is directly enforceable. This is an ecocentric approach, which means that nature, as a locus standi, as a legal position in front of courts, and the interest of nature can be brought in front of courts, even though there is no direct connection with specific individuals. So, nature and the environment are protected not only because they bring benefits to humanity, or for the effects that that degradation have on human rights, but also inherently for the rights of nature itself, disconnected from human beings. So the concrete consequence is that the right to a healthy environment can be invoked judicially, even in the absence of evidence indicating the existence of risks for specific individuals. In the following case, the case of the indigenous communities, the Laca Hornet, Our Land Associations versus Argentina, judgment of 2020, which relates specifically to indigenous peoples, the court found that there are several obligations for states to prevent environmental degradation in the name of different interests. But what is most important for us is that the court introduced the twofold dimension of the right to a safe and healthy environment, in the sense that this right has a collective dimension in the context of which it constitutes a universal value that is owed to both present and future generations, while in its individual dimension, this right retains its connection with other rights, so still in the dynamics of the greening of human rights. But it is not necessary, the court confirmed that it is not necessary that there is a direct connection between the environmental degradation and the specific interest of certain persons in particular. Then in 2023, we have this case, Caso Habitantes de La Oroya versus Peru, which is really a gold mine in the context of the topic that we are discussing. Because the court reiterated that the right to a safe and healthy environment is a fundamental right. But the court, and of course, one is free to disagree with this position, but it's notable anyway, the court concluded that the obligation to protect the environment is a peremptory norm of international law, so it must be considered as a rule of jus cogens, a norm accepted and recognized by the international community as a whole, from which an individual state cannot derogate. So no excuse can be used in order to claim a right to derogate from this right. And in its collective dimension, the right to a safe and healthy environment is a universal interest, which is due not only to present generations, but also to future generations. And this is a very important point, because the court has developed this point, saying that in reality, future generations start to exist today. And the court explicitly refers to the children that have just born or will come to existence in the future years, saying that the right to a safe and healthy environment is connected with the protection of the rights of the child, and that there is a stringent responsibility by present generation due to the diachronic nature of these rights, which means that there is a duty of present generations which are in a position of strength towards future generations, because present generations have the possibility to determine the effects that will be suffered by the environment, or better said, under this perspective of nature, while future generations will just suffer the actions of present generations. So it is particularly important that present generations act in a very stringent way in order to guarantee the safeguarding of a clean and safe environment in the interest of future generations. And then it is also reiterated that nature has legal rights in itself, with no need that these rights are connected with those of particular persons. Finally, we had the advisory opinion, very recent, number 32 of the 29th of May of 2025, so of this year, in which basically the court reiterates the principles that I have already described, and the fact that in the Inter-American system there is the existence of this right to a safe and healthy environment with a twofold connotation. So the collective dimension, in the context of which it is a right of universal character that is owed not only to individuals but to nature in itself, and the individual dimension in the context of which the position remains the same. The right to a safe and healthy environment is still connected to the rights of individual people, so to the effects of individual peoples. But there is an emphasis on vulnerable groups, especially indigenous peoples, and we will have discussion about the rights of indigenous peoples, which too often are considered just vulnerable groups and not human communities that can teach to us the way how the environment and nature should be managed in order to behave in a way that is really consistent with the requirements of sustainable development. And finally, there is again the recognition of nature as a subject of right. And of course, nature in front of courts must be represented by individuals, but the very new understanding of this right is that there is no need, again, that we have a direct connection with what is happening in a particular place. All human beings have a right to represent nature in front of legal bodies in the interest of nature itself. So even if this is disconnected from the interest of human beings specifically. And then, of course, there are a number of procedural mechanisms that must be recognized. So we have a number of stringent obligations for states that must ensure participation in environmental policies of all sectors of the society, especially those which are most disadvantaged and which most need that the environment is protected, because their life is much more related to the health of the environment itself, in particular indigenous peoples. So I think that the Inter-American Court of Human Rights, but we will see that the approach that is not very different is also being promoted by the African Court of Human and People's Rights, has introduced in international law a new idea of the right to a safe and healthy environment, an idea that, of course, must be furtherly developed, because it is in the interest of everybody and in the interest of nature itself. And this ecocentric approach is important, I would say, even though it may appear a contradiction in terms, but it's also important under an anthropocentric point of view, because saying that we protect nature only when there is a direct interest by somebody means that when there is environmental degradation, which has no particular effect for specific people, then the situation can be ignored. And this will happen to the detriment of future generations in particular. Having the possibility of recognizing an autonomous legal standing in favor of nature will be beneficial for everybody, and including human beings. Thank you very much.
Thank you, Professor Lenzerini. We now have, before our coffee break, some time for questions. If there are any questions from the public or the speakers. Shyness is there.
Yes, we
You always need an icebreaker. Apparently not. Thank you, Eugenio. Yes, break the ice, but you need to come here because otherwise people online will not hear you.
Well, thank you very much to the speakers for their brilliant insights into this very important topic. Well, my question, I'm not sure if it's really a question, but relates to the nature of the obligation that the ICJ in the advisory opinion of last July said to be inferable for this climate action. So the collective nature, the erga omnes nature of this obligation. I would like to hear your opinion if this, the approach of the ICJ in declaring the collective nature of climate-related obligations can in some way favor interstate litigation, maybe the emergence of cases related to climate change, if can some way, yes, let's say, yes, bring disputes before international judges, and despite all the, of course, the jurisdictional obstacles that the ICJ may face. And also it's curious that the ICJ in the same advisory opinion mentioned for the first time, if I'm not mistaken, that being erga omnes obligations, Article 48 of the ILC Articles on Responsibility applies. So it some way differentiates implicitly maybe non-directly injured states from directly injured states. And is that something that makes sense in your opinion? It can, I don't know, maybe, I mean, what is the purpose in the ICJ making this reference that it did not make in other, for example, human rights cases, such as, I don't know, Senegal, Belgium, or Gambia, Myanmar, where also erga omnes obligations were at stake? And well, I would have other insights, but I will stop here. Thank you very much for your attention. I don't know. The question is for whoever wants to answer.
Thank you, Eugenio.
Well, I will be happy to make a brief start, but maybe my colleagues will follow up. It's a very pertinent question, so thank you very much for it. Of course, the General Assembly raised these issues. They had differentiated a set of questions under question A, relating to all different fields, law of the sea, human rights law, international economic law, etc. But under question B, they also raised specifically the hot issue you did throw into the room. Huh? What about state responsibility? What about liability? What about the issue of reparation? And yeah, there I read the advisory of the opinion in two ways. Huh? On the one hand, they have been very brave by spelling it out. The response to this second question on responsibility and liability is much longer and much more to the point than I had anticipated. I had expected that they would try to reply only in a very general way and then stop. But basically, they give a very good analysis of what is at stake with responsibility and what kind of forms of reparations do exist. And basically, they build, without perhaps referring to it, very much on the very good paragraphs of the Inter-American Court of Human Rights, which also took up this issue in a very brave way. On the other hand, in the final paragraph, or maybe the penultimate one, they also say, don't expect too much from the role of law. Huh? We have made a modest contribution, and the role of law can only be modest. Huh? It has to be done in politics. Huh? And basically, you can also read prevention is much more important than litigation. But do know that litigation is possible. Also in view of the fact that more than 100 states, they mention the number of national constitutions and national environmental laws, which embody this notion of combating climate change as a legal responsibility. And then indeed, in a very good way, they refer to what is in the articles of the International Law Commission on state responsibility and the concept of reparation, including restoration of nature, including of compensation and other forms of declaration of law. So, thank you.
Yes, I see. Well, it's a very difficult question about, especially about interstate claims rising from not directly injured states for violations or climate obligations. I think that probably will happen like it happened in the human rights field, where for a long time, in spite of the fact that human rights obligations were regarded as erga omnes obligations, in spite of that, there were no interstate disputes, until the case appunto that you mentioned, Belgium and the other, and about genocide. And even now, the International Court of Justice is dealing with cases in which there is a treaty on human rights, the Genocide Convention, like in South Africa against Israel. And it seems to me the International Court of Justice has not, up to now, has not dealt with the case in which there was a claim based on erga omnes obligation instead of erga omnes partes obligations, no? Cioè based on customary international law or general international law. Even South Africa did not dare to make a claim under general international law, no? But it was more safe in relying on the Genocide Convention. But now in human rights field, in the last years, we have seen a growth of interstate claims based on human rights violations, especially concerning concerning human rights of fundamental importance, fundamental human rights. Now, I think probably the same will happen in the field of environment. I don't see now as very feasible a claim by a third state and not injured state in the field of climate change. But maybe with the development of the field in the future, I don't know whether in the near future or the more far future, maybe there will be interstate claims. And I mean, especially, as you mentioned, claims by not directly injured states. Although in the climate change field, probably many states may be injured, so directly injured. The distinction between directly injured states and not directly injured states may be more difficult in the climate change. But apart from the climate change, in environmental disputes, that is more feasible, yes, of course. Transboundary, there have been already many disputes about transboundary pollution, etc. But the climate change, I see more difficult to have now interstate disputes.
Thank you very much. Very interesting reflections. I will not deal with the issue under a technical perspective. In my opinion, and probably I'm not very adherent to the ways in which we should manage international law in this case. But in my opinion, it is always to be welcome when the judicial body has an approach which is not inspired that much by by technical considerations, but rather by what is necessary at a given time for humanity or for specific sectors of humanity. And I refer, for instance, again, I have been talking about the practice of the Inter-American Court of Human Rights. When the Inter-American Court of Human Rights has introduced its jurisprudence, which now is universally recognized about land rights of indigenous peoples, those land rights were not based on any existing rule, on any technical consideration. The court proceeded that way because in order to guarantee the quality of life to which indigenous peoples aspired, it was necessary to recognize their land rights. So simply, these moments in the history of international law, and I know that many scholars would disagree with this approach, but it is an approach that in many occasions have proven to be able to change the existing a number of respects. So it is an approach that, in my opinion, it is to be welcome because it tries to innovate the present characterization of international law in a way that is favorable to the people and to the development of human interest, and not only in this case human interest. And I would like to add that my students know this very well. I always advocate an approach according to which, to the extent possible, we should refer everything to human rights, because human rights offer the opportunity to bring individual cases or cases concerning collectivities in front of judicial bodies. This is not possible under, for instance, international environmental law generally, or this is not possible under international humanitarian law, or the majority of bodies of international law. So when we connect something to human rights, in our case, the right to the aspiration to a safe and healthy environment, that would bring to a positive development of the subject because human rights courts and human rights bodies in particular have this power to translate something that is necessary for the life of people into legal rules, as has been done by the African Court on Human and People's Rights in a number of occasions, the Inter-American Court, and the European Court on Human Rights as well, even though I have said at the beginning that personally I like much more the evolutionary approach of the other regional courts. And final point, because it was mentioned by Professor Schreiber concerning reparations. Who knows me also knows that I'm very sensible to the issue of reparations. And of course, the Inter-American Court of Human Rights has ordered reparations in the case that I have mentioned in the, of course, in the judgments, has ordered reparations for the people affected by environmental degradation. Of course, it is not easy to connect a right to reparation to the ecocentric approach, no, of environmental protection. Reparation is much more easy to be connected to specific interests of the persons and communities which are directly affected. But at the same time, the forms of reparations ordered by the Inter-American Court of Human Rights were not especially monetary reparations, but they were reparations aimed at preserving, of course, the right of the communities concerned, and I refer in particular to indigenous communities to live in a safe and healthy environment. But when you order the state to give guarantees of no repetition, which is the most frequent form of reparation ordered by the court in this case, then you protect the environment in itself. Because if environmental degradation does not occur any longer, you have a protection of nature, which is inherent, which is directed to nature in itself. So basically, I think that the most important role played by the judicial bodies, regional judicial bodies, especially the Inter-American Court and the African Court, has been to establish a direct connection between nature as probably direct connection is not the right expression, to establish that nature is beyond everybody in this world and it must be protected in itself. And the Inter-American Court of Human Rights refers not only to humanity but also to other species of animals and plants, exactly because of the inherent right of nature to be protected, which will correspond to an interest that will last for generations and is not just related to present people who are damaged directly by environmental degradation.
Just very short remark. I'm not sure I've understood what you meant for technical considerations, but I would insist on the importance of states' obligations and state responsibility in this field, because one of the defects of the right to a healthy environment has been brought about by within the United Nations system for many, many years, has been the fact that that concept was broad and vague, and also in the resolution of the General Assembly, there is nothing said about states' obligations. No, there is the declaration. There is now a right to a healthy environment, and is linked to other rights, but nothing about state obligation, not even about procedural obligation, except in the preamble there is something. Now, this is a defect of this whole development of this right within the United Nations system. While on the other hand, I think it's very important the greening approach that has been forwarded by the European Court of Human Rights and by the other courts, because the greening approach, linking the right to a healthy environment to other existing rights and well-developed rights, like the right to life or the right to private and family life, etc., has been more concrete. And if you look at the practice of the European Court of Human Rights, the cases you mentioned, many, many other cases, and the other, case law, the other courts, regional courts, you can build really a set of states' obligation and precise state obligation in the field of the protection of the environment. Now, with that, I don't want to say that it's useless to have a self-standing right to healthy environment, but what is useful is to combine the two approaches. The greening approach has been more concrete and more precise from a legal point of view. The other approach has the merit to have, come about with new rights, but to really understand the content of these new rights and the relative state's obligation, you have to look also at the greening approach. So I would insist on the advisory opinion of International Court of Justice is important, as Professor Schreiber said, because as I enter into the matter of the state obligations, and this is a great advantage of a ruling or of a court in respect to a soft law act like General Assembly resolution, in my view.
Just 2 sentences, and not to break the coffee break, but I really tend to agree with you, and I find it very, very positive that the court summarized its advisory opinion in very clear terms. There were lengthy questions, but the heading, the title chosen by the court itself is Obligations of States with Respect to Climate Change. And they go very far. The way they have summarized the obligations under the Paris Agreement is also an element of progressive development that was not understood in that way in November 2015. But of course, building upon the decisions of the COPs. The COP is now going on in Brazil, but COPs do matter. Really, the court went, probably beyond what you could expect to give a legal status to the decisions of the COPs and other conference of the meetings of the parties, of course, depending on the wording. And what I also found very interesting, the way they have summarized customary international law, did bring it back as a very important source of international law, especially also, my last point, to reach out to non-state parties, of non-state parties to be, because from January on, the United States is no longer a party to the Paris Agreement, but basically the court tells whatever your signature under the Paris Agreement, all states are bound by it, because for a large part it is also flowing from customary international law norms, the precautionary approach, the duty to cooperate, etc. So that I find that extremely positive. And then, of course, as far as reparation, they built on the Inter-American Court.
Yes, also, I will limit myself to a couple of sentences. I totally agree with you. In my presentation, I have been talking about obligations, procedural obligations, primary obligations. What I meant with the fact of not being too technical was a reference to the capacity of the Inter-American Court of Human Rights of drawing the existence of obligations, even though they cannot be directly drawn from the specific provisions written in the American Convention on Human Rights. So it is exactly this evolutionary interpretation which allows the Inter-American Court of Human Rights, the African Court of Human and People's Rights, but to a certain extent also the European Court of Human Rights, to establish state obligations, even when the written evidence of the norms would not present them directly. And the exceptional point, in my opinion, is that, of course, the greening approach is important. But the Inter-American Court of Human Rights has been able to find the existence of state obligations, not only in the context of the individual component of the right to a safe environment, so the greening approach, which is still today followed by the court, as I said, but also in the inherent right of nature to be protected. And this was a little bit more difficult, in my opinion. In the fact of being able to draw the existence of obligations of this kind, direct obligation for state, in the context of the collective component of the right to a safe and healthy environment, is an operation which is particularly evolutionary.
Okay, so we are now going to have a coffee break of 15 minutes. And we'll meet again here in 15 minutes. Thank you.
So welcome back. We start now a session, and the second session and the final session of this day. First of all, I would like to thank my friend and colleague, Federico Lenzerini, because he gave me this honor to be the chair of this very important session with so distinguished speakers. And I am a bit emotional, I must say, because I'm next to the people that wrote the articles and books that I have studied in order to become an academic. But I have also to blame him because of this, because it's a very hard task, in particular to introduce the speakers. I will start with the first one, who is Judge Rafa Benachur. He is judge. He has been judge at the African Court on Human and People's Rights since 2014. He is emeritus. He's a professor emeritus of public law at the University of Carthage in Tunisia. And he is a member of the International Institute of Human Rights in Strasbourg. He is the member of the Council of the United Nations University. It has been alternate member of the European Commission for Democracy through Law, that is also known as the Venice Commission. And I think that the issue of democracy has been probably one of the main issues that Professor Ashur has studied and has analyzed in depth. And I think that the issue of democracy is very important even for the right to a healthy environment. So I give the floor to Professor and Judge Rafa Benachur for his presentation entitled The Right to a Safe Environment from an African Perspective. Thank you.
Thank you, Madam President and distinguished colleague, distinguished guests, colleagues, and students, with a particular mention to the Tunisian students present today in this room. It is for me a big honor to take the floor in this round table, the second session of this round table, to reflect on theme of pressing importance, the right to a safe environment. I extend my deepest gratitude to Professor Federico Lenzerini and the University of Siena for the kind invitation to contribute to this timely discussion from an African perspective. I speak in my capacity as a judge of the African Court of Human and People's Rights, a position I have held since 2014. In this role, I have participated in the adjudication of cases that touch upon the very core of human dignity in Africa and the obligations of states to respect, protect, and fulfill the rights entrusted to them. I wish to place on record that I am, first and foremost, a Pan-African jurist committed to the principles of democracy, good governance, and the rule of law. It is essential to note that while this panel seeks to highlight an African perspective, this formulation may suggest that Africa's contribution is secondary or supplemental to global debate. Environmental protection is among the most pressing issues of our time, with consequences that cut across borders and generations. Africa's perspective one that treats environmental rights as collective, interdependent, and essential to human dignity, is not peripheral. It is pioneering. The global community has much to learn from this approach. Africa's recognition of environmental rights predates and enriches global human rights law. The African Charter of Human and People's Rights, adopted in 1981, was the first binding international instrument to codify the right to a satisfactory environment. The collective framing adopted by the Organization of African Union, today African Union, founding members state, underscored that the right is held by peoples as much by individuals. Notably, only recently has the United Nations General Assembly recognized this right universally through resolution number 76-300 of 2022. This resolution reflects a collective awareness that there can be no human dignity without a livable environment, nor human rights without environmental justice. It marked the culmination of decades of advocacy, and it builds on, among others, the 1972 Stockholm Declaration, the 1992 Rio Declaration, and the work of regional courts and the wider civil society. Clearly, Africa demonstrated jurisprudential foresight and ensuring the right within the Charter decades before it was acknowledged at the universal level. Let me point out that environmental rights are not isolated guarantees. They are deeply independent with other rights. For example, the rights to life, to health, to water and housing, to development and to culture. In many respects, the right of a satisfactory environment enhances and conditions the effective enjoyment of all three rights. The right to a safe environment is fundamental in our current global ecosystem, especially in the face of unpredictably brought about by climate change. As has been noted, as climate change continues to accelerate, biodiversity loss deepens, and environmental catastrophes persist, producing new forms of inequality marked by nationality, race, class, and gender. My foundational argument today is that Africa's distinct contribution has been to treat environmental rights not as an individual luxury, but as a collective duty. They are rights we hold together. They are connected to every other right we enjoy, and they come alive through three essential elements: fair distribution, full participation, and effective remedies. To develop this, I will first interrogate what we mean by African, then turn to the jurisprudence and institutions that have shaped this perspective. Secondly, I will highlight Africa's positioning in the hierarchical global paradigm, which tends to privilege Western voices and experiences. It is necessary to point out the realities of global inequality and the disproportionate effects of climate change before moving to my final point, which emphasizes that the African perspective cannot survive without global cooperation and a collective, tangible move to justice. What is an African perspective? Let me start by restating the obvious. Africa is not homogeneous. With 55 countries, more than 1.4 billion people, and over 2,000 distinct ethnic groups and languages, any claim to an African perspective must appreciate nuances in culture, racial, and ethnic diversity, as well as intellectual and jurisprudential traditions. As Amina Mama has written, Africa embodies, I quote, multiple identities, fluid historically and institutionally constructed along various dimensions of difference, and continuously contested and redefined in social process and struggles. End of quotation. The African Court carries a mandate to respect and safeguard these identities in alignment with human rights. This mandate is grounded in the African Charter, reinforced by regional treaties such as the Maputo Protocol of 2023 on the rights of women and the Kampala Convention of Protection and Assistance of Internally Displaced Persons, and shaped through jurisprudence that emphasizes collective rights. The African Charter, Article 24, affirms that, I quote, all peoples shall have the right to a general satisfactory environment favorable to their development. As earlier pointed out, this collective formulation is distinctive. By framing the right and belonging to peoples, the African Charter reflects Africa's plural identities and the shared solidarity that underpins its human rights system. The African Court has interpreted Article 24 in harmony with other provisions of the Charter. For example, the right to life, Article 4, to health, Article 16, natural resources, Article 21, and development, Article 22. This method demonstrates that environmental rights in Africa are siloed but integrated into the broader architecture of collective survival and dignity. For example, in African Commission on Human Rights versus Kenya, this ruling of the court observed that, I quote, the rights to religion, culture, and the environment are inextricably linked with land. End of quotation. This reasoning affirms that Africa perspective is holistic. Environment is interwoven with identity, culture, and community. Apart from the African Court, other regional institutions have reinforced this approach to dealing with the right to satisfactory environment. For example, the East African Court of Justice in Ano versus Tanzania in 2014 blocked a proposed road through the Serengeti National Park, reasoning that, I quote, the environment has intrinsic value and must preserve it even the absence of immediate human harm. End of quotation. This reflects an African vision that values nature itself as part of shared heritage. Taken together, these pronouncements show that African jurisprudence articulates a vision of environmental rights that is collective, diverse, and interdependent, shaped by the continent's multiplicity of culture and peoples. Jurisprudence and institutions. The African Commission of Human and People's Rights decision in Serap versus Nigeria in 2001 was the first to reaffirm the justiciability of Article 24 of the Charter. It held Nigeria responsible for failing to protect the Ogoni people from the oil exploitation, establishing that states have positive obligations to prevent harm, regulate private actors, and provide remedies. The African Court, in the Ojak judgment, a decision in which I am proud to have participated in, both at the merits stage as well in the reparations phase, the court found that eviction of the Ojak violated not only their land rights, but also their rights to culture, religion, and environment. The case illustrates the court jurisprudential method treating environmental rights as interdependent with dignity, culture, and development. Most critically, however, and pertinent to today's discussion, the landmark decision in Ligue Ivoirienne des Droits de l'Homme, LIDO, confronted one of the gravest environmental disasters in the continent, the dumping of toxic waste in Abidjan by a multinational, which name is Trafigura. The court found that the toxic waste caused deaths, widespread illness, and environment devastation, violating the rights to life, health, a satisfactory environment, and effective remedy. It condemned Côte d'Ivoire impunity deal with Trafigura, which shielded preparators and did very little to assist the victims, included hundreds of thousands who fell severely ill and at least 17 of who died as a result. This case is significant of a number of reasons. Firstly, it acknowledged the human rights implications of the dumping of the toxic waste. Second, it brought to the fore the responsibility that states bear in respect of activities of multinational corporations, where the same results in human rights violations. Third, it emphasizes that there is no place to impunity in respect of liability for human rights violations. The latter bit being apparent in the critical view that the court took of the settlement negotiated by the Ivorian government and Trafigura. This decision, Lido decision, was an unequivocal reminder that an African perspective of environmental justice requires confronting both state negligence and corporate abuse in the pursuit of advancing a goal of unwavering stance towards the right to a safe environment. Yet, while these developments are significant, we must also recognize the limits of our regional system. For example, the greatest weakness of the African Court lies not in its jurisprudence, but in the implementation of its judgments. As Shenwi and others note, in the Niger Delta, despite the Commission's strong ruling in the Serac case, I quote, "There has been little or no change to the actual environmental condition endured by communities. Too often, decisions remain only partially enforced or neglected altogether. Political resistance, sovereignty claims, and lack of resources hinder the transformation of legal recognition into lived reality. The African Court has not fared any better as the majority of its decisions remain unimplemented by state parties. This gap is especially acute in environmental matters, where remedies may require technical expertise, sustained funding, and cooperation across multiple state institutions. Without implementation, communities continue to suffer despite the strength of the court's pronouncements. Realities of environmental justice and inequality. Acknowledging the above weakness compels us to highlight the disproportionate burdens of environmental harm. Low-income and majority communities, and especially those in the global south, bear the heaviest costs of pollution and displacement. While wealthier society invest to renewable transition, African communities often suffer ecological damage for which they bear little responsibility. The Lido case starkly revealed how multinational corporations armed with resources and political influence can escape responsibility while local communities endure illness, death, and lasting environmental damage. Gender inequality compounds these harms. Women face disproportionate consequences of land degradation and climate change, from food insecurity to water scarcity, underscoring the importance of the Maputo Protocol. Equally, intergenerational equity reminds us that the gravest burdens will fall in children and future generations. It must be reiterated that Africa's approach remains distinctive. Where other systems often isolate environmental rights, Africa integrates them with development, culture, and collective survival. The African approach is an acknowledgement to that injustices cut across class, race, corporate interests, genders, and generation. In the end, no court, however principled, can secure justice alone. The implementation gap shows that cooperation is not optional but essential. Protecting the environment requires dialogue across institutions, consistent jurisprudence across regions, and coordinate monitoring of compliance. It must also not be forgotten that international attention is growing. It is in this context that I wish to bring to your attention the fact that the African Court has been invited to contribute to debates on climate change with a request for an advisory opinion pending. At the same time, African states are pioneering green initiatives from renewable energy projects to youth-led innovation in infrastructure and agriculture. These efforts show that Article 24 does not oppose development, it inspires sustainable forms of it. Cooperation, both within Africa and with the wider world, will therefore be key to ensuring that these examples are multiplied and that our jurisprudence brings tangible benefits to communities. To conclude, the African Court jurisprudence teaches that the environment is central to human dignity. To safeguard life, health, and development. As judges, we are guardians of interdependence. By ensuring effective remedies and by acting in solidarity with other institutions, we fulfill our mandate to protect both present and future generations. In my work as a jurist, I have emphasized that democracy and the rule of law cannot flourish without accountability. The same is true of environmental protection. Recognizing a right to a satisfactory environment imposes on states not only a duty to refrain from harm, but also a positive obligation to act effectively. It is here that law, governance, and the human rights converge. Before ending, I want to reiterate that an African perspective is not one which should be an afterthought in the zeitgeist of environmental justice, nor should it be one which is only considered when discussing issues of environmental protection with or about Africa. It is a humanist, cultural way of understanding in an African proverb, Ubuntu, meaning I am because we are. We exist, live, and breathe because our environmental does too. I also hope you might consider that the African perspective is not one which should be limited to speeches or conferences, but one that can be convivially adapted to all institutions, courts, governments, and peoples. Thank you so much for your kind attention.
Thank you very much, Judge Ashur. I think that you perfectly described that the right to a healthy environment is a form of democracy and concrete democracy. So now I give the floor to the second speaker, that is Professor Rüdiger Wolfrum. Professor Wolfrum is a professor emeritus of public international law at the University of Heidelberg. Professor Wolfrum was is the honorary director of the Max Planck Foundation for International Peace and the Rule of Law. As you see, there are some concepts that are recurrent. And Professor Wolfrum was a member and the president of the International Tribunal for the Law of the Sea. And he has always been interested in those goods and areas that nowadays are called the global commons and areas beyond national jurisdiction. He has been a pioneer in this sense, and he has been also a pioneer in the analyzing solidarity as a principle of international law. So when it was not yet a fashionable issue, but he analyzed this issue. So I think that we are very interested and thrilled to listen his presentation on the right of indigenous peoples to the land where they can enjoy their autonomy, substantive standards based on solidarity and limitations. Thank you, Professor Wolfram.
Thank you very much, Madam Chair, for introducing me. You didn't mention that we met in Tromsø within the context of the environmental protection of Antarctica, and this was my last meeting at the chair, on the chair of the Committee on the Protection of the Environment. But let's things like that unsaid. I'm speaking as an academic, although most of my life I've been also acting as a judge. And I'm very much feel honored to be called to participate in this conference for a reason you will perhaps not so easily understand. It is for somebody from Heidelberg very, very important to be called to participate in a conference in a university which is older by 100 years than the oldest German university in Germany. When I speak of German university in Germany, sounds double, but the first German university is in Prague, and the second German university is in Vienna, and therefore we are only number 3, but the first in Germany. Having said that, I very much appreciate the patience of students. At least 50% remained compared to the first session here, and let's hope they don't feel it was not worth it. Having said all that, let me go into details. I will speak more about indigenous people than about solidarity. There, everything has been said for a couple of reasons, but I will come back to that at the end. For a long period, indigenous people were only considered by a small group of experts, although the land issue attracts since a while more attention. In this context, I would like to mention the PhD thesis from Katja Göcke, who has lived together with Australian Aborigines and with Inuits in northern Canada. And therefore, these are quite different subjects, and has been writing about the land issue, in particular from the point of view that land means the identity of the Inuit people or the indigenous people in general. It was, however, particularly on the Inuit. I remember a statement of one of the leaders of the Hopi Nation, perhaps you have heard of it. The Hopis live in Arizona. When I asked him why the Hopi Nation did not engage in mining, the area is a desert, but full of uranium, gold, and copper. He stated, and I quote more or less verbally, "We Hopis only take from Mother Earth, which he is giving willingly. Mining is not giving willingly. I would rather be a poor Hopi than a middle-class US American." He was a well-educated man, and he served as a captain of a destroyer in the Second World War. Therefore, he had a status in the United States, but still was very critical about the United States, and very, very fond of the Hopi Nation. I learned a lot from him when we had a long talk about the traditions of the Hopi Nation. This is a nation which follows the matrilingual system. You are not related to the clan of the father, you're always related to the clan of the mother, etc., etc. He explains that in detail. The view he expressed rather strongly is the view which is well reflected in the declaration of the Convention Against Racial Discrimination, to which I belonged as a member for, I believe, 12 years. Namely, it's a particular relationship between indigenous people and the land they live on. In a recent report, the NGO Survival International, the report is not that old, just a week, has stated that there existed at about 196 uncontacted tribes, that's a term of art, mostly in the Brazilian rainforest, and were facing extinction due to the lack of respect concerning the land such tribes live on. Outsiders, driven by economic interest, endangered the foundation of the basis of the living of the indigenous. However, also missionaries, tourists, etc., endangered the health, lifestyle of the indigenous. The report's statement that the members of these tribes live, and I quote, a happy life, should be read with some skepticism, I must confess. How could a report say that a member of an uncontacted tribe live happily? This tribe has not been contacted. And therefore, one should look into this statement more carefully. What is the infrastructure of that tribe? What is the hierarchy? Is it a tribe who lives according to the system of the Aztecs with human sacrifices, etc.? Therefore, we should not believe in something like les nobles sauvages also, but look into reality. Having said that, I emphasize, I strongly believe that the autonomy, the traditions, the culture of these indigenous tribes should be fully protected. And that is a complicated issue. For in the moment you start protecting such groups, you unfortunately interfere with their traditions, their culture, the way they conduct business, etc. And therefore, this is a very complicated task we have to protect these groups. And I believe that's a must. And at the same time, protect the autonomy and the values of these groups. I may come back to that in a little bit later when I speak about some examples. There are at least two main concerns in respect of the position of indigenous people, namely that's the fact that the indigenous people are frequently complaining that they cannot participate in the decision-making, not even in the decision-making after international deliberation, if they are the subject of these deliberations. You know what happened recently in Belém. This reaction of the indigenous of the Amazonas region is correct, has to be understood, and I believe was to be expected if somebody would have taken care what was happening in this region. I've seen something similar when I was in Sudan. There are certain areas which are inhabited by nomads. And these nomads I'm referring to are protecting the excavations the German archaeologists do. These are particular temples and buildings which cross the bridge between the Numidian and the Pharaoh culture. The last two generations of the pharaohs are the black pharaohs. They come from this area. We had our wonderful archaeologists. They do a splendid job, but to come into the desert to celebrate that they have given back the altar in the temple to the people by reading poetry in German, 40 degrees in the shade, this is a little bit out of, let me say, the reality. And the shepherds and all these who were participating, they were invited, they knew what was happening, except they don't speak and understand German. After half an hour listening to Rilke and others, decided to have a nomadic dance of the shepherds. This was fantastic. This was totally different from what was expected by the organizers. And this was the German Research Foundation was there, the German ambassador was there, the Sudanese Minister of Culture was there, etc., etc. You can imagine. Wonderful adventure for everybody, and I liked it every bit. Be it as it may, it was respected, and when I visited a year ago this place again, the archaeological work had continued in spite of the war in Sudan, and I asked the leader of this team, are you not afraid there's war in Sudan? The armies fighting each other. And she said, no, never go to Khartoum. We have everything here, and the nomads, they protect us as we protect the nomads. And this is a symbiosis, for we are doing the excavation and the work to show the identity of this ethnic group there. They did a test, very funny. Perhaps it was theater. All workers had to show, if they wanted, that their nose was exactly the same nose as of the pharaoh, the black pharaoh depicted in this temple. And then it's clear this is our pharaoh, our temple, etc., and we protect it totally. This is perfectly correct and well done. As far as the question of participation, it's more a question of non-participation, is concerned, this has quite some tradition. Already in 1923, Chief Descahiers of the Six Nations Confederacy of the Iroquois, these are the Indians living at the Great Lakes, attempted to address the League of Nations. He was not accepted to speak. This is not a good point in favor of the League of Nations. The situation has changed a bit, but we may hear more about that from my neighbor to the right. For new mechanisms have been established, such as a special rapporteur on indigenous 2001, and the establishment of the expert mechanism on indigenousness in 2007. I shall not attempt to evaluate the activities of them. They may be speaking on behalf of the indigenous, but probably filtered. And this has not been taken as participation of the indigenous. It is a matter of fact that mostly indigenous rely on the mediation of NGOs. They hardly ever are allowed to speak on their own, which may, again, I don't make any accusation, kind of filter. Apart from that, the indigenous groups have very often not a homogeneous view about what is necessary. This I could clearly see in the deliberations of a new constitution of Chile, where I was participating. And I took the possibility to visit the Mapuches, which is the strongest ethnic indigenous group in Chile. Those living in urban centers wanted something in particular, being in the parliament. Others living in the rural areas wanted to be left alone, and the elderly amongst them still decided they follow their old traditions. Therefore, I had to sit in a ceremony where I was blessed with water, earth, and trees. But there is also the problem of the young people. We heard one of the leading political figures of the Mapuche, she wanted certain participation, and her daughter, 21 roughly, said simply, in the presence of her mother, without any hesitation when we asked directly, she wanted to be an ordinary Chilean woman, period. How can we say that these ideas approaches can be properly bring about and being implemented. This is the problem, what we are seeing. Let me now turn to the international standards concerning indigenous. We have international treaties. One may speak of one as an evolving process of the regime. That's a process, not even a straightforward one. It goes steps forward, two and one backwards, or occasionally one forward and two backward. It depends. For example, the concentration on the Mapuche language is in fact a step backward. For one concentrates on one thing which is easy to solve and forgets the rest, namely the question on the land rights. The question of the land rights is a very important element for the Mapuches, for the land has been taken away from them. And they are now competing with the German settlers in this particular area. We heard long stories when we spoke to them in this respect. I would like to emphasize the UN Declaration on the Rights of Indigenous People and the 2022 International Decade of Indigenous Languages, but here again, languages only, not the Aboriginals. But the most, in my view, I'm an academic, breakthrough was something else, namely the acknowledgement that human rights, including indigenous, are not individual rights, but collective rights. And they can being exercised individually, like the UN Declaration on Human Rights, which is individual-oriented, whereas the protection of the indigenous people has to take the indigenous as a collective body and a collective ownership of certain rights. My starting point when I go to the standards is the International Convention Against All Forms of Racial Discrimination. It is one of the first human rights treaties. It was adopted for a very simple reason. The states couldn't agree on the two covenants, and therefore they took off the racial discrimination problematic, for this is easier to solve unless the covenants still boiling, and they were adopted many, many years later. The Committee Against Racial Discrimination in 1996 adopted a declaration after the General Assembly had proclaimed the International Decade of the World's Indigenous People in 1994. A general recommendation, it's General Recommendation 23, and I will not read out what it states, that's boring. I will only mention 3 points, I believe. And there I will quote verbally. The committee is conscious of the fact that in many regions of the world, indigenous peoples have been and are still being discriminated against and deprived of their human rights and fundamental freedoms, and in particular that they have lost their land and resources to colonists, commercial companies, and state enterprises. Consequently, the preservation of their culture and their historical identity has been and still is jeopardized. You have seen the pictures of Brazil, of the Brazilian rainforest. There we have, as I said, more than 190 indigenous groups. But the land is permanently taken away from them. Although the president of Brazil, the new one I mean, the old one didn't care, still allows gold digging, doesn't stop the illegal taking of gold, which ruins the environment. for the indigenous are totally depending that the environment is clean and healthy. And your need for digging for gold, to use quicksilver to wash the gold out, and which pollutes the rivers or the water and the earth. And if the animals feed on this or drink this polluted water, it is in the meat of these animals. They are also polluted. I was with a group of indigenous, not in the Brazilian rainforest, but in the Argentinian rainforest. And they exactly told me, we face the pollution directly and indirectly. This indigenous group, this particular one, had a deep knowledge about the nature, the healing possibilities of the plants, and the orientation in the rainforest. At one moment, we were told, where is a camp? There were probably 10, and we all pointed in 10 different directions. I would have not found the camp again. For the reason I lost totally the orientation. And this is typical, but they have it. Further, this declaration says, provide indigenous people with conditions allowing for a sustainable economic and social development compatible, and underline the word compatible, with their cultural characteristics. Next point, to ensure that members of indigenous people have equal rights in respect of the effective participation in public life, and no decision directly relating to their rights and interests are taken without their informed consent. Therefore, you have to have first a discussion with them, and then you have to ask them, do you consent? It's all not happening, in spite of what Argentina or Brazil or Uruguay says. The committee especially calls upon states parties to recognize and protect the rights of indigenous people to own, develop, control, and use their communal lands, territory, resources where they have been deprived of their lands and territories traditionally owned or otherwise inhabited or used, without free and informed consent. I believe I've bothered you enough with direct quotations. You see, the point is the land issue and the participation issue is a central element for indigenous people. Let us have, I'll soon come to an end, look into the national standards. I mean the national standards of Latin American states where they have indigenous people. I first mentioned Bolivia. The Constitution of Bolivia provides for the protection and promotion of indigenous communities. Their right to land is guaranteed, as well as the autonomy of such communities with the state. This constitution is implemented and is mostly functioning. Article 2 of that constitution reads, given the pre-colonial existence of nations, that's the justification, and rural native indigenous peoples and their ancestral control of their territories, their free determination consisting of the right to autonomy, not self-determination, autonomy, the word is carefully chosen. Self-government is also not self-determination. A recognition of their institutions, particularly the decisions by the chiefs, the council of chiefs, the medicine man, etc. The consolidation of their territorial entities is guaranteed within the framework of the unity of the state in accordance with this constitution and the law. This is well drafted, Article 2. It's speaks of the unity of the state for good reason. Indigenous people have not the right of secession. You must find their rights, autonomy within the state. This works, as you can see it in Bolivia. Also interesting is Article 3. The Bolivian nation is formed by all Bolivians, the native indigenous nations, or you have a Bolivian nation and an indigenous nation, and peoples. Besides these nations, there are peoples. These are not the original inhabitants, but newcomers like African or Spanish origin. Therefore, again, a sophisticated drafting explaining well the situation of indigenous people. What do we find in Brazil? Game? No, not at all. It's very simple. Union has exclusive power to legislate with respect to indigenous population. End of the story. This gives the government of Brazil, the central government, carte blanche. And the Brazilian government uses this carte blanche. Again, another example, New Zealand. Here we have only one indigenous population, namely the Maoris. The Maoris were different from the Aborigines in Australia. The Maoris were very, very good warriors. And therefore, they objected and were fighting against the British colonial power. This resulted, this fighting, in the Treaty of Waitangi, adopted on the 6th February 1840 between, how many was that? The United Crown, not the United Kingdom government, the Crown, and 540 chiefs. That's quite a big group. And there are several different texts. They were signed with 540 signatures. But this is still not a treaty between the United Kingdom, but between the Crown and the chiefs. And this is why the Crown still has an eye on the protection of the Maoris. This treaty is significant. It establishes a partnership between the Maori and the Crown, requiring both parties to act with good faith towards each other. I use the original wording. The Maoris have the right to participate in decision-making processes regarding their lands, waterways, and ancestral places. The Crown has a duty to protect Maori interests, rights, and the language. The Crown is committed to achieve equitable health outcomes for Maori. We are now in the middle of this seminar, as far as the topic is concerned. The Crown must provide for and properly resource Maori health and disability services, which has been done. The Crown must provide redress for any breaches of the treaty, and the Crown must consult the Maoris before making decisions that affect them. The present situation of New Zealand is there's a particular electoral right which gives the Maoris the right to have their own list, which only they can vote in favor, and they have a certain guaranteed seat in the parliament, and there are certain offices which the Maoris have to govern or administer. These are 15% of the population of New Zealand, and the language of the Maori, which we cannot read or not speak, is treated as an equal language, but please believe there's only one minority group, one indigenous population, not several. The situation in Australia is, as you know, totally different. The Aborigines were and the Torres Strait Islanders were very peaceful people, different from the Maoris. Occasionally that's counterproductive. And they were very, very much mistreated. And it went so far that while I was in the Committee Against Racial Discrimination, as the Australian government had reported about the treatment of Aborigines, and the committee decided that this treatment was contrary to the law of the Racial Discrimination Committee. And it decided, normally you report every 4 years, that the government of Australia had to report again after a year. This is a rather strong message. We are not satisfied with you. This report was equally not satisfactory, and therefore the government of Australia had to report again after half a year. Then they learned the message and promised certain changes in their policy, particularly the protection of the sacred land. The Aborigine have a particular feeling for the land. They believe that the land has a spiritual function, etc. Now, I will not go further into that. Now, what is the principle of solidarity can do in this respect? If you have a majority group and a minority group, this principle of solidarity means that the majority respects the existence, the autonomy, the laws, and the customs of the minority. This is, they are given the weight and the attendance and the tolerance those deserve. But solidarity is not one-sided. Also, the minorities must accept that there is a majority, and they should not overuse these minority rights. I'll give you one example, which caused a lot of trouble in Australia. The Australians have a certain system of punishment of members of the group. These punishments are occasionally quite drastic. I refer to a case where they decided that juveniles who had broken some of the Aboriginal rules were sent into kind of a prison. It was a room which was totally dark, no windows whatsoever, and a pot of water and a little bit of dry bread. There, the argument from the government was, oh no, this is torture. And even if you have your autonomy, you can't do torture. The case ended up before a human rights committee and a compromise was found. And here we have the tolerance, but there is a limit to the tolerance which solidarity cannot overtake. Also, the protection of the land is, as I described it for Bolivia, you can explain best by the principle of solidarity. No gold digging, protection of the water, protection of the forest. The majority may want to do it differently. There's one element which has been mentioned in the advisory opinion of the ICJ on climate change, which is traditionally overlooked. Just a sentence for a couple of words, perhaps under 10. It says, traditionally we define a state as a territory, the population, and the governmental force. This could be done without the territory. The ICJ has done this to signal that they would accept the Pacific Islands who are going to vanish still remain states. Let's be sure. This is totally contrary to the traditions of international law. Totally. If somebody had told that 10 years ago or 3 years ago, would have declared this is nonsense. But the ICJ, which is quite a conservative body, has in this case decided that as a matter of solidarity, we have a different status for what is a state. It will open a discussion, but it will make it easier for the people on these islands, which will vanish due to the sea level rise. They still will retain their maritime land. Sounds strange, but these islanders don't consider the water as sea, but they consider the water as part of the land, and therefore will still govern their huge areas of maritime zones. But this is come. I could stop here, but the devil drives me to raise a question. We have discussed about many things, but we did not discuss what is a proper dispute settlement mechanism to fight against climate change. We all believe, I say, for me, use the past perfect, we believed, just a second, that national courts are a good alternative to do it via human rights. Let me. Are we totally sure about that? Here we have the claims brought mostly by NGOs. Are they really fighting for the protection of the marine environment, or do they fight for their own interests? If you look into the judgments, what becomes binding in the judgment is not what the claimant asked for. Check what I've said, and this is some homework for you to do. Thank you very much for your attention, and that you didn't leave me.
Thank you very much, Professor Wolfram, for your still pioneer view and your proactive view for the vanishing small island states that is going to raise issues even concerning sovereignty, state sovereignty. Thank you very much. And now I would And so now I introduce you our third speaker, Professor Daly Sambo Doro. He's Professor of International Relations at the University of Alaska, Anchorage. And she has been the former international, she has been the international chair of the Inuit Circumpolar Council. She is currently the Arctic region member of the UN Expert Mechanism on the rights of indigenous people. She is the chairperson of the UN Permanent Forum on Indigenous Issues, and she also the co-chair of the ILA, the International Law Association Committee on Implementation on the Rights of Indigenous People. Probably I imagine who is the other co-chair. And then she's a great expert on Inuit people and on indigenous people, you can understand. And she's going to make a presentation that will make us close to the concept of symbiotic relationship between human beings and the environment. The presentation of Professor Sambo Doro is our distinct relationship to the natural world, the collective right to a safe, healthy, and sustainable environment. Thank you, Professor Sambo Doro.
Ana Qiyanakbak Uvanga Daily Sambo Doro. We're at the end of a long day.
Oh, no, it's okay.
Oh, okay. At the end of a long day. Actually, I noticed a couple students return, so this is a good sign. As a former and very active professor, I used to keep very close track of these matters. So allow me, first of all, to acknowledge Professor Lenzerini and his generous invitation to join you today. I greatly appreciate it, not just him, but also his wonderful wife, Erica, and family, whom I've had a chance to meet and learn more about. I so rarely do this, but I also want to acknowledge my husband, Luke, who joined me all the way from Anchorage, Alaska as well, and for his support and encouragement. I have the task of adding the human face to this discussion about the right to a safe, clean, healthy, and sustainable environment. And I am willing to say, and I think I can be sure about this, that Inuit and indigenous peoples have exercised and enjoyed the right to a safe, clean, healthy, and sustainable environment long before it was even conceived of by the international community, and certainly all the way up, at least in the Americas, in my case, 1491. And all of you know the trouble started after 1491. But this is to say that much of what has been shared today in terms of the development, or I dare say the progressive development of international law, has finally come full circle back around to the reality and the voices and the natural world of indigenous peoples. I think that it has been very constructive to track these developments. I think Professor Lenzerini used the term evolutionary. There have been a number of different terms that have been used, but I think that my main message through this PowerPoint presentation is that we're now regaining a place. It's been a slow process, but we're regaining a place both in terms of objects and subjects through international human rights law. This is a photograph of Eben Hobson. Internationally, he's recognized as the founder of the Inuit Circumpolar Council, an organization that I've had a long-standing engagement with ever since high school. In 1977, in Utqiagvik, Alaska, the northernmost point in Alaska, he welcomed our Inuit relations from the Russian Far East, Alaska, Canada, and Greenland to a conference in order to unite our people across our traditional homelands, an effort to erase the imposed borders of the United States, Canada, Russia, and Denmark. In his welcoming remarks, he said many important things, but this quote is really important to the right to a safe, healthy, clean, and sustainable environment. Our language contains the memory of 4,000 years of human survival through the conservation and good managing of our Arctic wealth. Our language contains the intricate knowledge of the ice that we have seen no others demonstrate. I think this is true to this day. He's speaking volumes about an important relationship between Inuit and the environment. I'll dive a little bit deeper into this concept. I urge you to find this welcoming speech by Eben Hobson, again in June of 1977. Since that day, Inuit have linked arms across imposed borders and done some extraordinary things to influence, especially international human rights law. We've heard the term holistic, and I won't read the entire quote, but it is very clear, not just the Hopi, but from our perspective, everything is interrelated, interdependent, interconnected, and indivisible, just like the nature of human rights. Take a holistic view of the environment. Here, this is a quote from an important report that the Inuit did about food sovereignty and self-governance. One of the individuals said, "When you live in an area, you become part of the environment. We are part of the environment. We have been sustaining this environment for thousands of years without degrading it." This is from the perspective of a hunter, somebody who has been out on the land and the sea ice day after day and hour after hour, patiently waiting and coping with the conditions in order to sustain themselves and the integrity of their community, their people. Of course, reciprocity and responsibility. We know about rights and responsibility in human rights law, but the same value applies to Inuit and has been expressed through Inuit. For thousands of years, Inuit have been a part of the ecosystem, thrived and built their culture rooted in these values, centered on the relationship that they have with everything in the ecosystem. And these values, respect, collaboration, and sharing, all aid in supporting healthy and harmonious relationships to the environment and other species in the environment, as well as Inuit communities. Here again, like the nature of human rights, everything is indivisible. Again, if you alter one element, and we know this in human rights, I'm adapting it to exercising a right to a safe and healthy environment. You alter one element, one part of an ecosystem, it has cascading effects, right? We know this. And it can impact everything, including the food security or the overall integrity of a community. So again, from this Food Sovereignty and Self-Governance report, the walrus, char, beluga, salmon, Inuit share this environment and our species within ecosystems, teeming with bowhead whales, seals, polar bears, cod, seaweed, and on land, caribou, freshwater fish, muskox, berries, roots, and bird eggs. And the big argument that we had with Greenpeace in the late 70s and the early 80s, maybe some of you know about this history. Out of the blue, the International Whaling Commission decided that we better put a ban on the harvest of bowhead whales. Well, they didn't know about this intimate and profound relationship that the Inupiat people have with bowhead whales. One of the arguments made, certainly to the US Congress and others within the US administration, whom we were lobbying to show up at the International Whaling Commission to defend our right to bowhead whaling. One of the arguments was made by a person named Charles E. Took Edwardson, who said that it's too bad that the conservation community, the environmental community, has chosen not to safeguard the Inuit. They want to safeguard the whale, but not the Inuit. But the Inuit are a species in the same way that the whale is a species. There's a relationship, and there's incredible protocol and values, and I dare say indigenous legal traditions that have sustained this relationship from, a year-long preparation, the role of the women in the community, the role of the men in the community, the role of the children. It's very, very sophisticated. One would never know this by showing up in the community and having a look around the village. You have to know it through the knowledge and the language that Eben Hobson was speaking of. This is a group of people from the community in this photograph using block and tackle to haul probably about a 40-foot bowhead whale. Take note that every foot is about a ton. These people are working together to harvest the whale, who in their mind and through their relationship know that this whale gave itself to the community. This, again, cultural, but more importantly, spiritual relationship is an element, a direct element of the food security of the people. But also the food security, as noted here, is characterized by a healthy environment. We also know the relationship that if there's an unhealthy environment, in all likelihood, the community, the people are unhealthy because of the significance and importance of that relationship between indigenous peoples and the natural world. This is referred to as a reciprocal relationship between the environment and the environment that individuals are a part of and collectively a part of. One reason I took this quote from the Food Sovereignty and Self-Government report is that participants also shared this element of happiness being felt from this relationship. Again, an animal giving itself to the hunter and providing for the community. There's an extraordinary celebration that takes place after the successful harvest of a whale. Stewardship over ownership. Now, the Western world has a different concept, common law, and everything that we faced since first contact has a different understanding of ownership and control of the environment. The views of indigenous people is, again, this relationship, these practices with the environment. And I think that there, in addition to spiritual, there's social, economic, cultural, and indeed political dimensions to the relationship. Land doesn't represent simply a possession or means of production. This is significant. It was recognized by Jose Martinez Cobo, the principal author of the very first voluminous study on the status and conditions of indigenous peoples worldwide. Physically, it's a stack of paper about this high. It's accessible on the internet if anybody wants to go back to his work in the 1980s to survey the status and conditions of indigenous peoples worldwide. But here, the statement is so important at, again, a time before there was even a discussion about a safe and healthy environment. The land doesn't represent simply a possession or means of production. It's essential to understand the special and profoundly spiritual relationship of Indigenous peoples with Mother Earth as basic to their existence and to all their beliefs, customs, traditions, and culture, everything about them, including the Inuit. Because of the pressures that Inuit were facing, not just with the International Whaling Commission, but because of the threat of offshore oil and gas development. I won't get into the 1989 Exxon Valdez oil spill. Probably most of you in the room were born after that time, but never mind. It was a tragic event with thousands of gallons of crude oil spilled in Prince William Sound, one of the most beautiful places in Alaska. This was a threat, offshore oil and gas development, International Whaling Commission, atmospheric pollution. The Chernobyl incident had taken place. We, since 1977, have seen just amazing things take place across the Arctic, our homelands. So Inuit decided to develop their own comprehensive principles for an Arctic policy. And again, this is in the 1970s and 1980s. If you were to study anything about the Arctic today, you would learn that every single Arctic nation, as well as nations far from the Arctic, have now adopted Arctic policies. My point is that well before anything like this happened, Inuit had prepared an Arctic policy, largely because of the challenges that we were seeing day in and day out. Here, Inuit embraced what I've been saying, that we're an integral part of the Arctic ecosystems. And for generations, subsistence or our harvesting activities have been and continue to be in harmony with and an important part of Arctic ecosystems. And again, this profound relationship. We took this Arctic policy, it's available also now online as well, and utilized it as essential guidelines for defending our human rights and lobbying decision makers for policy favorable to us. In the Food Sovereignty and Self-Governance report, Inuit hunters primarily shared the barriers that impede food sovereignty. I would venture to say, and I think it's a pretty solid statement, that Indigenous peoples, and certainly I know for a fact that Inuit and other Indigenous peoples in Alaska are the most regulated individuals in Alaska, if not the most regulated people on Earth. Every single thing about us every day is regulated by the state government, the state of Alaska, or the federal government, or even, as some have already shared here, the interpretations and understanding of international human rights law. So again, because of the challenges that we've faced, we chose to advocate in favor of ourselves, for ourselves, in order to maintain the integrity of our people and the Arctic environment. This was a very early proposal that was made in relation to the UN Declaration on the Rights of Indigenous Peoples. And we put forward essentially what everyone is now calling the right to a safe, clean, healthy, and sustainable environment, that we have this unique and spiritual relationship that is different from others, and that we hold the land collectively, not as individuals, and that it is crucial to all the different aspects of our lives, culture, personality, religion, sovereignty, autonomy, self-determination, everything. So this was one of the proposals brought forward by Inuit, and it was memorialized in one of the UN documents. This was a part of our effort to take the Arctic policy and interpret it into human rights standards, which now make up the UN Declaration on the Rights of Indigenous People. The preambular paragraph of the UN Declaration this is huge in my estimation. So in part, that programmatic approach of the right to a safe and healthy environment that Professor Shriver spoke about earlier, these are hints at what we need in terms of a muscular and robust interpretation of the right to a safe and healthy environment. Recognizing that respect for Indigenous knowledge, cultures, and traditional practices contributes to sustainable and equitable development and proper management of the environment. We spend a lot of time trying to convince people of this, especially at things like the COP30 and other international venues. So the UN Declaration on the Rights of Indigenous Peoples, Article 25, actually embraces this as well. That distinct relationship, the distinctive spiritual relationship with lands traditionally owned or otherwise occupied and used, territories, waters, and coastal seas. I'll tell you that at one point in time, because of Inuit, this language used to include the term sea ice, but because sea ice is not universal, it fell on the drafting room floor. But here again, it was an effort that we made to try to ensure that our perspectives were included in the UN Declaration. Nevertheless, Article 25 is a significant article or significant provision. And don't forget that it's interrelated to all the other provisions of the UN Declaration. Article 29, Indigenous peoples have the right to the conservation and protection of the environment and the productive capacity of their lands, territories, and resources, and that states shall establish this obligation of states to establish and implement assistance programs for Indigenous peoples for such conservation and protection without discrimination. These are early understandings of the right to a safe and healthy environment. I just quickly want to say that the International Labor Organization Convention number 169 also affirms this relationship that Indigenous peoples have to their lands and territories. I greatly appreciate the efforts. I was involved in this 1988 and 1989 revision process. The effort of Indigenous peoples, but also trade union members within the ILO who helped to enunciate that the total environment means the total environment, the air, the land, the waters, the subsurface, the total environment. Many may be aware of the American Declaration, the international instrument that emerged from the Organization of American States. Here again, this relationship between Indigenous peoples, Indigenous knowledge, as well as the contributions that especially Indigenous knowledge makes to sustainable and equitable development, as well as management of the environment. Here it is. Healthy, safe, and sustainable environment, essential conditions for the full enjoyment of the right to life, to their spirituality, worldview, and to collective well-being. Others have already shared these perspectives and how it's related to the health of not just the environment, but the health of the people, things like housing, safe drinking water, etc. Because of time, I won't get into it, but I think that it's significant that the ASEAN Declaration was put in place and that there is specific reference to Indigenous peoples. I think that the status of quote unquote vulnerable peoples, I'm not a big fan of the use of this term because we don't see ourselves as vulnerable in our own context and from our own perspective. Nevertheless, we are vulnerable in terms of the global crisis of climate change, as well as biodiversity loss and a host of other things, and challenge the right to a safe and healthy environment. But it's significant that the ASEAN Declaration does make a specific reference. I'm going to skip that as well. So in terms of the work of Indigenous peoples, the key principles or the key guidelines for advocacy has been the phrase, and maybe many of you have heard it, that there should be nothing about us without us, that we should be direct participants. Professor Wolfram spoke about the indigenous peoples at the back of the room, if they were even present in the room. But I would respectfully suggest that we as Inuit, in the defense of our rights and the interpretation and understanding of our rights, we have been present and very vocal in many of these various different fora because of all the challenges that we face. Many know that the Arctic is experiencing 4, maybe now 5 times faster rates of impacts of climate change than any other region in the world, with possibly the exception of Antarctica. We are seeing reduced sea ice, shipping traffic, the rate of tourism has exploded. I mentioned the offshore oil and gas development, unsustainable harvest, especially industrial fishing or commercial fishing by vessels that are not policed in any way, shape, or form beyond the exclusive environmental zone. Invasive species, the list, I have a much longer list than this, but we don't have time to go over it. What I want to get to is what we're doing in terms of what we see as global governance. We have the emergence of this right to a safe and healthy environment, and have kind of pried open the doors to ensure that we're present. We're engaged in many, many different international fora. We're the first Indigenous organization to become members of the International Maritime Organization. We depend on the marine environment. We are people of the marine environment. So it's logical for us to show up at the IMO and say, what about black carbon? What about underwater noise? What about, the long list of things that they prepare guidelines and regulations for? We're present there and have already been active in a host of different things. We're involved directly in the plastics treaty, and we're seeing microplastics in the marine mammals that we harvest. It's been this way for a long time. Finally, the world community has figured out, we need a plastics treaty. A High Seas Biodiversity Treaty, we were direct participants. In this case, we had to participate through the US government, through the Canadian government, through the Danish government, but we were at the table. The Central Arctic Ocean Fisheries Agreement, this small little donut hole in the middle of the Arctic Ocean. Everybody is interested in their food security, and namely China. So this treaty is the 5 Arctic states plus 5, including China. It's the only other international treaty that I know of that invokes the UN Declaration of the Rights of Indigenous Peoples and also specifically or explicitly references Indigenous knowledge. And we're direct participants in this program of science and research and Indigenous knowledge to safeguard our rights and interests in the Central Arctic Ocean Fisheries Agreement. This territory in red on this map, this is our traditional homeland. We're the longest linear cultural group in the world, stretching again from the Russian Far East all the way to Eastern Greenland. All of this coastal area our people depend upon. You go to a community and it might look like there's nobody there, but you can be sure that hunters, fishers, and other harvesters are utilizing this traditional territory far beyond these small, scattered, rural communities. The Pikiala-Soswak and Savajwak project is an effort in the small area between Canada and Greenland to promote Inuit control and management of the marine environment. Some of you may be familiar with the marine protected areas that the government of Canada has entered into directly with Inuit themselves. Our hope is that at some point in time, there'll be an entire mosaic of marine protected areas covering our essentially all of our territory, of which we have a direct role in managing and controlling because of our human rights and because of our reliance upon these marine protected areas. I could get into Hans Island Agreement, which actually recognizes that Inuit transit the border because of hunting, fishing, and harvesting rights. It's a significant development and a good precedent for our eventual hoped for erasure of the borders that have been, again, imposed upon us. So we've influenced the human rights that are affirmed in the UN Declaration on the Rights of Indigenous Peoples. We participated in the ILO revision process. We participated in the development of the American Declaration on the Rights of Indigenous Peoples. We are not going to remain silent in the area of our human rights. We could use the Human Rights Treaty body system more effectively, but our resources and our time and our energy is spread pretty thin. We believe that we have exercised and enjoyed a right to a clean, safe, healthy, and sustainable environment. The challenges are now so heavy and so powerful that we're going to have to institute an even more effective campaign to safeguard the Arctic environment. We're doing so through various different community-led initiatives like the Food Sovereignty and Self-Governance Project. Every fora that is relevant to us and that we have the resources for, we are there and present, furthering sustainable development and sustainable resource use. This is to uphold, again, our cultural integrity, our environmental integrity. And if one looks up the term integrity on your phones, I see some of you looking at your phones, you'll learn that integrity means something whole, something unbroken, something that has been safeguarded and held together. And in the end of the day, that's what our interest is to maintain our integrity and our relationship with the Arctic environment. And I have to say, as a concluding statement, in my belief, I'm sure that Indigenous peoples throughout the Amazon, throughout Australia, throughout the Torres Strait Islands, throughout Norway, Sweden, Finland, throughout the Pacific, they all want the same thing. They want to maintain their integrity. They want to uphold their responsibilities to future generations. And one of the avenues and pathways to do so is the right to a safe, clean, healthy, and sustainable environment. Thank you.
Thank you very much, Professor Sembodoro, for this passionate, fascinating, and in-depth analysis of what, and description that is very useful for people that are maybe not familiar with these inside views. Well, I know that it's a bit late, but I think that these three presentations, I would like to thank all the speakers because all these three presentations were really stimulating, and they allowed all our minds to open and to raise questions, because this is what academic research is made for, to raise question and to spend our lives in attempting to find these questions, the answers to these questions. So I open the floor for questions to the young researchers, so the young academic and the most experienced ones. So please, if you have any questions, please come here so you can speak over the microphone and the people at home may hear you. Yes, sorry.
I forgot to say, at the outset in the first session, someone made the remark that it's always difficult to get an icebreaker. And I wanted to shout from my seat that Inuit don't like icebreakers.
Yeah. So just a small remark from my side, just to prolong a bit of the discussion, because I have been really fascinated by all the three presentations. You provided a very different perspective from the typical perspective that we have in international environmental law. Usually international environmental law tries to protect the environment and, as you said, in the interest usually of human beings, but trying to combine different interests. While I think that the three presentations that you provided try to consider the environment as a part, this holistic approach. Do you think that this holistic approach may have a future in international law, considering the traditional approach of international law? In my view, probably reality will oblige international law to change. But what is your opinion about this impact of an holistic approach with respect to current or to the traditional international law? Thank you.
I think it's for you.
Okay. Yes, it took us in international law long time to accept the holistic approach. Originally, it was the protection of certain components. As far as I remember, the holistic approach was accepted first in the connection with Antarctica, where out of a sudden one spoke about the Antarctic environment as a holistic approach. It was very much disputed, particularly by some countries who use the Antarctic, particularly by whaling. And there the question was, do we really consider the environment as such? And shouldn't we not only consider the whales? That was the problem. But by now, due to Kamla, the holistic approach is now a matter of fact. Therefore, we go into this direction, which has been described by our last speaker very forcefully. Whether this, however, at the end of the day, is being done with success is another story. Climate, we do not move into the holistic system, unfortunately. For example, there are, at least in my country, which is over-conservative in this respect, we only look upon CO2. That's far from being holistic. One should also look into the question, how can we absorb CO2 from the atmosphere, which in Germany is prohibited. There you see that we have not yet a real system, coherent system in this respect. But if we start discussing that, we are sitting here until tomorrow night. Therefore, I would rather not recommend to open this can of worms.
No problem.
I think that we've already crossed the threshold. I think we've already crossed the threshold, but in terms of crystallizing it in international law that, as has been said thus far, that further work needs to be done in the area for it to actually crystallize in. And by this, I mean embraced by, for example, the man wearing the fossil fuel delegate at the COP30 to convince individuals like him that a holistic approach is really the only way to go. We all learned this when we were in middle school, that everything is connected to everything else. This food web, I mean, in basic biology, we learn this, and I think that in this area and this particular arena of a right to safe, clean, healthy, and sustainable environment, that it's only logical. It may take time, but that it's a logical path forward.
I will add only one thing, that in our approach in the African Court, we adopted this approach.
There is one problem. The approach that one should look upon the environment holistically and also include the hunting of certain animals has been rejected by the European Union due to the law of banning of the products of seals. You have argued, or the Inuit have argued, that this is your culture, etc. It didn't work. The WTO, at least in the committee, said yes, maybe, but there is a moral understanding. First time that WTO used moral reasons. Moral reason was just produced by Greenpeace, nobody else.
Yeah. Just add to that, because when Professor Lenzarini was speaking earlier and mentioned the rights of nature, specifically for Indigenous peoples, this is a very, very tricky issue, and it intersects somewhat. I won't get into a commentary on what you just said about the seals. I'm acutely aware of the highly problematic nature of the European.
Yes.
I could say many things better, but as far as the rights of nature for Indigenous peoples, this is a really tricky area, because the question is who speaks for nature, and I say this because of the problems that we have had with rabid and animal rights organizations who believe that they speak for the whale, or they speak for the ocean, or they speak for missing completely the cultural context of Indigenous peoples, or indeed others as well. I mean, if we think about the fisheries, for example, a host of other areas. So I think that it's well, again, I'll stop there. Thanks.
Thank you very much.
Well, I have a general question on the status of indigenous peoples, which may interest the students still here. Do you think that the indigenous peoples are a special kind of minority or something different? Is a minority sui generis or not? Because indigenous people don't like this kind of approximation to minorities, and they have avoided to be linked to the status of minorities because it had disadvantages. Minority is not well protected in international law, and they obtain a status which is probably better with the UN declaration. However, the problem still remains. The regime is only the special regime for indigenous peoples, which is probably mostly established by the UN Declaration, or they can also enjoy the regime of minorities, international law, Article 27 of the UN Covenant, etc., etc.
Okay. So please.
Thank you for the question. No, that's exactly right. I would avoid using the term special because the UN Declaration on the Rights of Indigenous Peoples, as well as other indigenous specific instruments, are not the creation of new rights. We're talking about a distinct cultural context. So it's a recognition of the status, role, and rights of indigenous peoples as distinct from minorities. And when I say this, I specifically mean the right of self-determination as an inherent right of indigenous nations prior to contact, the social order, the legal traditions, and the values and protocols, et cetera, of indigenous peoples, and also the rights to lands, territories, and resources. So I think that this is an important distinction in terms of, or against the backdrop of minorities. So the other dynamic that I think is important is that we're starting to see a different wave arrive in terms of a new challenge, and that is the linkage between indigenous peoples and local communities. Local communities is ambiguous. It's not recognized or understood in international law. In my estimation, especially in the Arctic, local communities might be Icelanders because they're communities, they're local to Iceland, but in the rest of the Arctic nations, it's clear who is indigenous, and for Iceland, who are representatives of local communities. In the rest of the world, what we're starting to see is the use of the term by governments in order to diminish the rights of indigenous peoples because they don't want to recognize their rights to land or their rights to self-determination or whatever else fits their economic agenda. So I just wanted to share that as an example again of the distinction between minorities and indigenous peoples, and clearly between indigenous peoples and quote unquote local communities. I have my own theory about why governments are insisting on this and how the term emerged in even at the Rio Conference on Environment and Development, the CBD, and all the other instruments that were spawned in Rio de Janeiro decades ago now. But again, we don't have time to get into it, but that's my quick response. Thank you for the question.
A final question, I would say.
In reality, this is not a question. Unfortunately, time runs very fast and we have to close our meeting. But I have to say that I just want to thank the speakers because I'm really honored that all of you have accepted my invitation. I mean, all our speakers are really giants in their respective field. And in comparison to them, I'm just a very little one. So I'm deeply honored that they have accepted to come here. And for me, this event is a sort of closure of a circle because Professor Wolfram said that since very recent time, only a very restricted group of experts dealt with the rights of indigenous peoples in international law. Of course, I do not pretend to be included among those experts, but when I started to deal with indigenous peoples' rights about 20 years ago, there was one of the most important contemporary professors of international law in Italy who told me, Lenzerini, but what kind of topic is that? I mean, indigenous peoples is not a serious topic of international law. And now we are here that basically all the speakers have been discussed about the rights of indigenous peoples, which is a key issue in the topic that was at the center of our event. And I want to go back to what you said about who speaks for nature. We discussed that issue yesterday as well. I will have only one answer. The international community has the Sustainable Development Goals that are very elaborated, very sophisticated, and they should be reached by 2030, which is really difficult. And in the Sustainable Development Goals, indigenous peoples are only conceived as disadvantaged communities who should improve their level of life. In my opinion, there should be only one Sustainable Development Goals. Observe how indigenous peoples behave with nature. Try to learn how they behave with nature, how they treat nature, what is their relationship with nature, and try to imitate their behavior. Then that would be the recipe for sustainable development. We would not need anything else. Yes. Thank you. Okay, many thanks to my students.
Good luck to you.
Thank you. Thank you.
Thank you very much. It was really beautiful. Not only
Yeah. Thank you. Yeah. Oh, you're welcome.
Thank you very much.